just to give the brief overview, because I said I would, I've been doing business law for 23 years. I got my regular law degree that all lawyers have. Then I did my postdoctoral work in tax law at Georgetown, got a second law degree. Went to work for really big law firms. I worked for 2 different ones nationwide, doing, billion-dollar deals, which that's what you want to do when you're in law school. And it was a lot of fun. But I realized that's not what my passion was. My passion is and has always been as a small business owner. I've owned about 20, probably 23 different small businesses myself over the years. I love to buy businesses. I love to build businesses. I love to sell businesses. I hate to close them down, but I've done all of those. So, I'm not just a business attorney. I'm a very experienced business entrepreneur. So I've kind of dealt with the same issues that you're going through or you're thinking about or you're contemplating. So I can bring that perspective as well. Our firm does everything a small business needs and nothing it does not. We're not trying to be all things to all people. We're not, trying to do a slip and fall case and then a bankruptcy and then figure out how to draft an operating agreement. That's all we do. And we've got a bunch of really smart attorneys who all kind of focus their practice in different areas. So I do M&A. I do buying and selling businesses. I do tax law. I do some employment law, stuff like that. Heather's one of our attorneys. She does litigation. So when you mess up or when somebody else gets mad at you, she's the one that jumps in and straightens out those problems. But we've got attorneys who do construction law, real estate. So if you're signing a commercial lease agreement, you probably want somebody to look at that. Employment law, intellectual property, so trademarks, copyrights, things like that. Pretty much anything a small business needs. It sounds like these were a list of questions that were kind of assembled from the questions that consultants usually or often receive. What legal steps should entrepreneurs take early to build a strong foundation for their business? Okay, the key here is early. And that is, if we're going to build a house, we want a good solid foundation. Same thing with a business. If you're going to build a business, you need it to be a solid foundation. And there's a few things that we look at there. Big one's probably going to be your organizational documents. So I have a superficial answer, and then I have one that's going to go into a little bit more depth. So we're going to hit both. So the first is you need good organizational documents. That's really what the foundation of your business is built on. And when you go to sell or when you go to bring in new partners, those are the documents we're going to look at to determine how that kind of transaction goes. So I want to make sure that we've got good organizational documents. So if you are a corporation or an S corporation is just a tax election. We'll talk about that in a second. Then you're going to have articles of incorporation that are filed with the Secretary of State's office. And then with that, we'll put together bylaws that kind of spell out how your governing board acts. That tells you how do we schedule votes and how do we have meetings and do all those kinds of things. And then if there are multiple owners, we'll probably have a shareholder agreement that explains, or a buy-sell agreement that explains, this is the relationship amongst the owners on how we're going to work together. Those are the kind of the core foundational documents. If you have an LLC, it's very similar, but it's slightly different. We're going to have articles of organization instead of incorporation, articles of organization. And then we're going to have what's called an operating agreement. Colorado law is like just about all the other states, that the laws governing an LLC are almost all default. So you can change just about all of them in your operating agreement. If you're fine with the default ones, and there's certain ones you shouldn't be, but if you're fine with those, then yeah, you don't need an operating agreement. You can just throw caution to the wind and hope everything goes well. But usually it's better to have a good operating agreement. And that does 2 things. It does the things, same thing that bylaws do, and it explains how we're going to govern and run the company. Then it also says, how are we going to own the company together as members? Because corporation has shareholders and the LLC has members. And it kind of covers both the bylaws and the shareholder agreement. Does that make sense? Here's the deal with an operating agreement. And I'll always shoot you straight, I'll always be direct, honest. If it's just you, if you're the only owner, you can probably get one off the internet and be just fine. Don't spend money on me if it's just you. And the reason is because you're promising with yourself how you're going to run your company. However, and I mean this so sincerely, if you're going to have a partner, and I don't care if it's your best friend since you were like 2, you need an operating agreement. The operating agreement is going to kind of solidify expectations and how we're going to vote on certain matters and what kind of voting percentages are required to take certain actions. What happens when one of the well-intentioned parties stops performing? Because we see that all the time. Do you have any rights to kick them out, or do they get to freeload off your work for the next 10 years? So that's why you need an operating agreement, even if they're your best friend or your mom or your dad, your sister. And I joke about this. It cost a couple $1,000s to put all this together and do it the right way at the beginning. If you don't, it costs about $80,000 to $100,000 to unwind it. Yeah, and I love it because I do it all the time. Like, it's good money for me, but don't be that guy, you know? So just do it right. Get an operating agreement in place from the beginning. And as long as you do that, that's the core foundational documents that you need, okay? So if it's a corporation, bylaws and a shareholder agreement. If it's an LLC, an operating agreement. If you get that foundation and you do it right, you're going to be in a great spot going forward. And here's where it comes up. I'll give you just some more stories. A lot of times what we see is two people come in and they've got really good ideas and intentions, and then all of a sudden somebody has a change of, outside circumstances. They've got to move for a family issue, or they got sick and they stopped working, or one of them just decided that they're actually kind of lazy. But these things happen, and then all of a sudden we've got a company that's running and kind of needs both people, but it's not getting the attention both people should be giving it. And then we've got this tension and this frustration and this kind of anger that grows over time because I'm pulling my weight, but my partner's not. And then what do? Can I kick them out? Do I have to buy them out? What does that look like? So an operating agreement should cover all those different things. It should have contingencies in place for, what if I have to remove somebody? We have a bad boy clause in there. So if you go to jail, we get to buy you out. We get to buy you out at a discount because you put the company and the other owner in a bad spot. So the bad boy clause. There are a bunch of other things that can go into that. What if you're getting divorced and your ex-wife or spouse wants to take your ownership in the company? Well, I wanted to be your partner. I did not want to be partners with your wife. So if your wife is going to get your share of the company in the divorce, I have the right to buy her out at a big discount, which means she's not going to take that in the divorce and you get to keep it. So it's good for you. The foundational documents would be the most important thing I could recommend right off the top.
One issue I keep seeing, and I don't know, it's so simple, is once you get your organizational documents and you sign them and execute them, so you need to scan them and send them somewhere.
Signed ones, signed copies.
The signed ones. People just keep losing them, the signed versions, and then we have, a litigation dispute and nobody has the signed agreement.
Yeah, question.
To add on, you mentioned divorce. What happens if you build a company and you do end up getting a divorce or something? What do you recommend beforehand? Like, the spouse had no business creation with it whatsoever, but yet, you got that now, I'm going to take it.
That's a great question, because now we've got to intersect with two areas of law. One is family law, and that's going to govern your relationship with your wife or your spouse with respect to division of marital assets. That controls. But then we've also got contract law or business law that's going to govern the company's ownership and maintenance and obligations. A court in a family law scenario could say, hey, we're going to split up the equities. So if, there's a teeter-totter, and if you get the house, then she gets this, and if she gets that, then you get that, or if he gets the car and you get the, it balances out. So if you're going to take the business, that's going to push down on the teeter-totter, we're going to have to balance it out another way. And there's usually a way of doing that. You can buy them out, you can do other property, payments to equalize that. But from a contractual standpoint, yeah, we can also put some protections in place, and we do, that say, I own this. This is contractually mine. If you try to take it, my partners have a right to buy you out at a steep discount. And so here's where it gets tricky, and this is why it works. It works. I've done this hundreds of times probably. Is fine. The business is worth $1 million, so it goes on this side. So I get $1 million to balance out that teeter-totter. But the moment that you take it, my partner gets to buy you out for $700,000. Ooh. Now all of a sudden that doesn't look too right, because I got $1 million and you're only going to get 700 out of it. I do have one going right now where they're going through a divorce and they're going to run the company together. We've done that a few times where we figured out, okay, you're going to do operations here and you're going to do manufacturing here. So it can work.
What are some common legal mistakes small businesses make during their first few years?
Oh, goodness. Okay. Number one is not having a clear agreement with your owners and partners and everybody who's going into this. Like, what am I going to do? What are you going to do? What am I putting in? What are you putting in? Did we all actually put everything in? We just broke up a business. We're in the middle of it, like doing the settlement agreement right now, where our client put in $150,000 and the other side was supposed to put in, but he only put in 10. And so, we're trying to break it up. We're like, hey, you actually never put in your money. So what does that do to our agreements? So making sure that whatever the original agreement is, make sure you've got that documented. That's usually where an operating agreement comes into place, or a shareholder. Make sure you have a good CPA and good bookkeeping. You got to know where all the money's coming in and where it's all going out. There's a lot of money that can go through a business, and it gets really scary when you start to sit down and you realize, like, I'm used to being a W-2 employee and I get a paycheck and expect my paycheck, pretty easy. Then all of a sudden you've got all this money coming in, you think all that money's yours, but you've got rent, you've got insurance, you've got, all these other expenses. If you're not tracking it, you don't have somebody who's helping you plan that's going to be a big issue. So make sure you've got a good CPA who's helping you with that. So you're good on taxes, but also so you're just making good sense money-wise. Does that make sense? Third, insurance. Get insurance. There's a lot of liabilities out there that some you may know about, some that you may not know about, but just get a good insurance broker. Don't sign personal guarantees, please. But you probably will. I signed personal guarantees on a ton of my businesses, and I finally got to the point where I didn't have to.
What is a personal guarantee?
Oh,
How do
okay.
you describe personal
Yeah, personal guarantee usually comes up in the form of you're signing a lease agreement, and the landlord says, that's great, I really want you to be here as my tenant, but your business is brand new. So your business is going to be the primary obligor, but I want you to personally guarantee the performance and payment of that lease. So if the business fails, you're still on the hook personally. Yes. For about $12,000 a month. I know that very painfully.
So that is very common, like in leases, rental properties?
Yes.
Businesses? Okay.
Very, very common. It's also in a lot of loans. All my bankers are like, yes, we do personal guarantees.
That's what I was going to say is that I experienced it more in the lending side,
Mhm.
and it was non-negotiable, and we needed the money, so we signed personal guarantees.
Yeah.
So, quick question in regards to personal guarantee. At what stage of your business you don't require to be guarantor?
Okay, so here's where a good attorney can help you. Because sometimes I can negotiate that. Say, what if we give you a guarantee for the first 2 years, but after that it goes away? And sometimes I've been successful at getting that. Sometimes you just never get away from it. An SBA loan, you're guaranteeing it. If it's over a certain amount, you're putting your house up, your children. They never took my kids.
Could you comment on joint and several guarantees?
Okay, joint and several. Yeah, I can cover that too. So a guarantee is personal to me. But let's say that there's 3 of us and we form a business together. Well, they can say we want it to be joint and several. So in that case, it means that we each individually are guaranteeing the full amount. Now, they can only collect the full amount, but they can collect the full amount from any one of us. So it's not like I can come in and say, we're borrowing $100,000. I'm a 25% owner. I only owe 25% of that if things don't go well. No, I own it all. I got to pay 100% of it. Now I could have write a contribution to go after my partners to try and recover it. But if we're in default, they probably don't have a lot of money either, right? So, yeah. So what we got? Okay, one was organizational documents, CPA, insurance, personal guarantees. I think the other thing that comes in play here really early is lease agreements. And I mention this all the time because we sign them and we don't often think about what we're actually signing. This is usually a really big commitment. It's not like I'm buying a piece of equipment for $20,000 or $50,000, which would be a big purchase. No, I'm only going to pay them $4,000 or $5,000 a month for the next 20 years. That's a huge commitment. A lease agreement is a big commitment. So before you jump into a lease, make sure you have somebody look at it. An attorney can help you with that. So lease agreements, and then my last one is employees. No matter how hard you try, anybody who's working for you is most likely an employee and not an independent contractor. You can't get away by saying, well, I had them sign something. If they're providing services for you, they're most likely an employee. There are some ways where somebody can be a true independent contractor, but the areas that we end up digging people out of holes real quickly is you make them an independent contractor. You're not withholding taxes. You're not following all the employment laws that you're supposed to follow. And then they get hurt and they go file for workman's comp insurance. And they say, well, you're an independent contractor, so there's no coverage. They go, I'm not a contractor, I'm an employee. And then they come back and say, yeah, you actually are an employee. Now here are a whole bunch of penalties. You got to pay all of their taxes. You got to do a whole bunch of things. So the penalties and the downside of mischaracterizing an employee are very high. So before you take on a lease agreement or employees, be sure to talk to an attorney. Those are the 5 big ones that I was thinking about before.
I have a question about insurance where Heather's concerned. So the business owner gets the right insurance and then they get sued, I think I know the answer, but I'm just double checking. Then the insurance, if they afford the coverage, will work that litigation until those coverages are exhausted, and then you come in.
Well, no, that's a great question. So insurance usually covers two things. One is it's going to cover covered claims. So, if there's a liability at the end and there's coverage, then they pay that. But the first thing that they do that's more important, often, they provide defense.
Right.
So sometimes your total coverage policy gets eaten up by the cost of defense, and sometimes it doesn't. So that's something to figure out. But it's important to have the right insurance because that claim could be totally frivolous, right? But you don't want to go out of pocket trying to defend it. That's why we have insurance. So the insurance defends it, and then if you're successful, you're done. But if you're not, at that point, then they would cover any covered claim.
And sometimes the insurance will cover it. So you get a demand letter from somebody. Sometimes insurance will come in and look at the demand letter and issue a response. Most often, they wait until the lawsuit is filed.
Right.
So pre-litigation, you're not covered. It just depends on your insurance policy.
That's super important too, because pre-litigation is where you can lose the case real fast too.
Yeah.
So if you get the demand letter, talk to an attorney real quick and make sure, hey, are we doing the right things? You don't want to start staking down positions and tie yourself to a losing battle. Does that make sense? It could be we could go this way or this way. And if you wait for an insurance company to come in and provide defense, you could be well down that path and have closed the doors.
And you might know this from the insurance side too, is that a lot of times our clients will talk, well, my insurance covers this. Okay, well, let's look at your policy. And they'll bring that 4 to 5 page, document. And I'm like, this is not your policy. So oftentimes people don't have actually their entire policy. They have to go to their insurance and request it. So you can do that up front when you get your coverage.
So let's say I get sued. I'm working with you guys already. I let you know and let my insurance company know, and then just take your advice and then just wait to see if I get sued, and then let everybody know what's going on.
Usually your insurance policy has a duty to report. You have to look at the trigger.
Right.
Yeah.
Let us know when you get served, but
Yep.
then still talk to you in the meantime, right? Just don't
Yes.
shelve that.
Yes.
Okay.
Yeah, because we could probably respond to it, do a bunch of things. We might even settle it and resolve it before it even goes to a lawsuit. That could be good for you. What do you got back there, John?
Yeah, in terms of employment agreements, you mentioned that it sort of non-compete agreements. Could you talk about the enforceability sort of broadly, and then here in Colorado as well?
They're not. They're pretty much not. Don't do it.
Yeah.
Do not do it unless you really, really talk to an attorney who says you can. It used to be, we're going to go back about 7 years. It used to be that you could do a non-compete agreement, and they would be enforceable if it was for the protection of trade secrets in connection with the sale of business, to repay the cost of funded trade school or certain things. There were 4 areas where you could get it. And usually I was successful in getting it in connection with the sale of business or for the protection of trade secrets, but it had to be narrowly tailored to the protection of trade secrets. The covenant not to compete also had to be reasonable in both duration and geographic scope. There were a whole bunch of rules, but we could pack a lot of them into that. And so they were everywhere.
What about non-solicitation agreement?
Non-solicitation is the exact same as covenant not to compete.
Really?
Yeah, they're treated the same. But the statutes changed recently. So about 4 years ago, they said, no, that's not the rules. Now you have to be a highly compensated individual. So you have to be making a lot of money and have to also be narrowly tailored, usually to the protection of trade secrets. But more importantly, here's the big kicker. If you ask your employee to sign one and it's not enforceable, you're subject to a big penalty. All they have to do is say, you asked me to sign this, and you're writing a $5,000 check. So don't do them. Don't do them. I've done so many people out. And then here's my favorite thing. You have to give them a separate written notice that tells them what's in the document that you gave them. So if they didn't read the document, they're going to read the notice and understand it all. I swear. That's how it works. Good question.
Does that relate to solicitation of employees as well?
So there's 2 things that come up there, but yeah, pretty
Because I worry more about an employee who leaves and then tries to hire my key managers in a firm that's probably going to compete.
It is, and the key on that's going to come down to when that solicitation occurs. If it occurs while they are employed, they have a duty of loyalty to the company, and they violated that duty, and now there could be damages. If it occurs after, then they can do that. That's a great question right here.
What is something that you find that businesses mess up a lot that turns what they thought was somebody that was just running off commission turns them into an actual company?
Okay, here's the deal. if they're performing services for you, they are an employee. Unless, okay, there are 4 different laws, 4 tests. There's the Colorado Department of Revenue. There's the Federal Department of Revenue, the IRS. There's the Colorado Department of Labor. There's the Federal Department of Labor. 4 different agencies, they all have different tests. So if you want to go through, it used to be there was a 3-part test, then it became an 8-part test, then it became a 23-part test, then it became a 5-part test with 8 subparts. Okay, that's great. But here's what it means practically. If that person is not independently and actively engaged in their own trade or business, providing those same services to other people, they're an employee. So even if they're only working part-time and just helping you a little bit, they're an employee. Unless they, if I come over and I change the windshield on your car, but that's my business and I've got, a warehouse and I do that, then I'm clearly an independent contractor. But if I come over and I just work a cash register just 2 hours a week, I'm an employee. So, and the other part, to kind of summarize all of those various tests, if that person is financially or economically dependent upon you, they're an employee, okay? If they do not have the ability to reap a windfall or suffer a loss from performing these services, they're an employee. So if they can do it faster and make more money, that's one factor that might help you. But if they're paid by the hour, they're an employee. So Colorado enforces this. It's an area where we do a lot of kind of defense. So that's a great question. There's another one over here.
You mentioned insurance and lawyers. How do you do your due diligence to pick the right one? How do you know you're going to the right one worth their salt?
No, that's a great question. I think people, clients and lawyers find each other or aligned. And this is going to sound terrible, but my clients are almost always the good guy. Why? Because I'm a good guy. I'm an ethical guy. I'm upfront and I'm honest, and I'm going to make sure my clients are doing the same thing. And if there's a misalignment there, that relationship isn't going to survive and they're going to go somewhere else, or I'm going to push them somewhere else. I'm not saying every time, but almost every time when I'm dealing with somebody on the opposing side who's kind of slimy, I can tell you which lawyers they're going to have, because those lawyers are going to be the same way. So I think people and their lawyers find each other, and I'm not going to let my clients do bad things. I believe that the tax laws, I'm a tax guy, I believe that the tax laws are designed to be used. So if there's areas where we can find advantages, we're going to use them. But we're going to do it ethically. And I'm never going to tell you, hey, I know you're not supposed to do this, don't tell anybody. Never going to do that. So when you find an attorney who has the same values as you, you'll know.
How important is choosing the right business structure, and what factors should owners consider?
I love this. S Corp LLC, you guys have all heard it, you've all thought about it, right? 1,000,000 times. There are right answers, there are wrong answers, but there's very few that are kind of like absolute. So here's an absolute one. Never ever put real estate into a corporate entity. Okay? That's like one of the very few, like, never do it. And the reason is, I could put property into a partnership and pull it out without it being a taxable event. Anytime you put property into a corporation, you have to be 351 to make sure it goes in tax-free. But if you pull it out, it's a taxable event. If you transfer certain ownership, it could be a taxable event. So it could be that you never even sold the property, but you have to pay tax on the appreciation. And when you're pulling it out, it could be a headache. So never put real estate in a corporate entity.
Are you talking about LLCs or just S Corps and C Corps and stuff?
Anything taxed as a corporation. Okay. But that would be an S Corp too. But you never want to put real estate into an entity that's taxed as or is a corporation, just because that's good for profit. So the common entities, you can do business as yourself in your own name. Sole proprietorship, that's me. I open up a bank account, I do business, sometimes I have a trade name. Great. Super flexible, but the problem is I have 100% liability. I'm completely exposed. There's no separation between my personal and my business side. You can form an LLC, it costs $50. Just do that.